Here, there we go. So go ahead and click that you accept if that pop-up button comes up. Now you should already see my slideshow, the first page. As many of you know, we'll be covering a HOA legal update for this year, which covers both the most major change to the Davis-Stirling Act that went into effect January 1st of this year, 2021, but also a recap of some important changes that occurred last year, January 1st, 2020, which kind of got swept to the side in light of all of the craziness that the pandemic presented, but still nonetheless is important for HOAs to know about and respond accordingly. So without further ado, let me just go over a quick background of myself. I've been practicing for about 16 years now, largely in HOA and real estate matters, primarily litigation, but of course, as part of the real estate practice, you also encounter a lot of transactional issues. So we've handled all sorts of purchase sale matters, boundary easement issues, title, and HOA, of course, as well as co-ownership and partitions. I'm part of Kaufman, Dolowich, Volek, and we have a really dynamic real estate practice group. My offices are both in San Francisco and Sonoma, but our practice and our reach really goes beyond that. I personally have practiced for nearly 2 decades now in the Bay Area, including the practice areas that I've listed here. So we have a lot to cover today, but I promise to keep it quick and just give you the bird's eye view and invite you to ask questions. I will try to, from time to time, let's see, I don't have the slideshow view. Let me know if you can't see that. And I'll keep an eye on that too. Hopefully it's just one person that may need to click on something. But anyway, I will try to keep an eye on the chat box as well as the Q&A and try to answer things from time to time as I switch topics. Okay, I can see the agenda slide. Great. So we do have quite a few topics to cover. We will cover, of course, the change that went into effect this year, the change to the Davis-Stirling Act. And then we'll recap some significant changes in the past year that went into effect in 2020 and some important cases that came down in 2019, which directly affect HOAs in California. And of course, no presentation these days would be complete without at least a comment on the impact of COVID-19 and the shelter-in-place orders. And so we will address some of the practical issues that HOAs have faced in the past year and some best practices that we have developed over time. So first, we will discuss Assembly Bill 3182, which went into effect January 1st of 2021, and it is a significant change to the Davis-Stirling Act in that it now clearly states that HOAs cannot prohibit renting or leasing in an HOA, and any type of regulation that attempts to prohibit renting or leasing is considered invalid. It goes on to specify that HOAs cannot limit leasing to less than 25% of the HOA or development. That does not include restrictions or outright prohibitions on short-term rentals, which is defined as 30 days or less. In other words, HOAs are still allowed to prohibit short-term rentals, even in light of this new law. But aside from short-term rentals, HOAs can no longer limit leasing to less than 25%. It also specifies that rentals of ADUs, accessory dwelling units, are not included in this 25% floor. In other words, if the HOAs restrict leasing to 25% of the entire HOA or development, which is now valid under this new law, that cannot include owners' rentals of their ADUs. Another significant aspect to this law, which is fairly novel in the way that the Davis-Stirling Act was amended this time. And that is, which I've put in bold here, HOAs must amend their governing documents to conform to these new requirements. And they must do so no later than December 31st of this year. I have always advised HOAs up until now, at least up until the last year, that if there was a change made to the Davis-Stirling Act, while of course it's best practice to update your CC&Rs to reflect the new changes in the law, it did not, the failure to amend the CC&Rs did not render the CC&Rs invalid. In other words, HOAs were not required to affirmatively update their CC&Rs to reflect any changes in the Davis-Stirling Act or in applicable law. This is somewhat the first of its kind, Assembly Bill 3182, in that now HOAs are affirmatively required to amend their governing documents, and they must do so by the end of this year. I caution HOAs too, December 31st may seem like a long time away, but if there is any requirement that that the HOA must conduct an amendment by secret ballot, which I'll get into in a moment, it's amazing how quickly this time can fly, because if there is a requirement to update the election and amendment processes in the CC&Rs, there's a 90-day waiting period before you can vote on anything. So if the goal is to update CC&Rs in order to reflect current law under this new Assembly Bill 3182, it is important really to get started now, unless you're already working on it and you've got an annual meeting around the corner. Assuming that's not the case, HOA should really think about what their timeline and process will be in order to amend their governing documents before the end of the year. AB 31, does it apply to co-ops? Arguably, yes. The Davis-Stirling Act applies to both co-ops and any common area development, plan unit developments as well. So there's a whole host of other applicable laws that may apply to co-ops that do not apply to HOAs, but this Assembly Bill 3182 does also include co-ops. The other aspects of this new law pertain to ADUs specifically, which I won't get into too much here because they don't necessarily involve HOAs. It's ADUs in general. If you remember, effective January 1st of last year, 2020, there was a whole host of new policy changes allowing the construction of more ADUs and local governments being required to facilitate that as much as possible. So I see Assembly Bill 3182 as expanding and reiterating that policy change that went into effect last year. But just keep in mind that there's a whole host of other provisions in this new law that pertain to ADUs specifically. And then these next two slides that I just skipped through very briefly, I will share this slideshow for future reference. But just keep in mind, there's quite a bit on ADUs and how local governments should be facilitating the construction of those. So just keep in mind that that's another big aspect of Assembly Bill 3182. That affects all properties, not just ADUs. I mean, not just HOAs. Okay, a question came up about if our CC&Rs don't address rentals, do they still need to be amended to address 3182? It's a good question that I've been getting a lot in the last month since this law went into effect, and that is, to what extent are HOAs required to amend their CC&Rs if the CC&Rs do not explicitly violate this 25% rule now? And there aren't any answers, unfortunately. I typically advise HOAs that the best practice, once again, is to just ensure that the CC&Rs are compliant with this new law. So to answer this question, if it's silent on rentals, I actually recommend, for a number of different reasons, that the HOA take it upon themselves to address leasing specifically in the CC&Rs. You want to give your members, the homeowners of this HOA, as much clarity on what they are allowed to do versus not. And so in that vein, you'll want to be clear that 25% or more, depending on what the HOA wants to do, at least 25% of that development must allow leasing, and ideally have a process for how owners can take on that right to lease. It's typically a first come, first serve process, but there's also a number of preconditions that HOAs may want to consider. Of course, if there's no provision at all in the CC&Rs prohibiting short-term rentals, that should be addressed as an HOA. Do the homeowners, does the board want to allow it or not? So for a lot of reasons, if the CC&Rs are silent on leasing, it is a good idea to update those CC&Rs, and ideally before the end of the year. Small HOAs, yes, this is another question that I get a lot. In general, the Davis-Stirling Act applies to small HOAs, and I'll define that for what it's worth in a moment, as opposed to large HOAs, if you will, and we're talking hundreds, if not thousands of units. There's no distinction as a practical matter under the Davis-Stirling Act between a quote unquote small HOA versus a large HOA. In other words, all of these rules, all of the provisions of the Davis-Stirling Act apply to an HOA as small as 2 units, all the way up to the thousands of units. And so as a practical matter, this becomes very cumbersome, as you can imagine, with small HOAs, where the formalities may not necessarily apply. But the reality is those formalities still must be abided by, even in an HOA as small as 2 units. And so how it fits with this bill, if there's something like 25% minimum leasing, just keep that in mind. That in effect means for a 2-unit HOA that at least one of those units gets to be leased in order to comply with this new law. And then same idea, if the CC&Rs need to be amended, just keep in mind they have to be amended before the end of this year. Is there a penalty if HOAs do not comply with this new law? I always say there's no condo police, so it's difficult to say to what extent an HOA may be penalized. It's not as if there's some condo agency that's going to issue a notice of violation. That said, because the law now requires HOAs to affirmatively amend their CC&Rs, there are 2 issues that I see coming up as a practical matter. One is insurance coverage. If there is a homeowner that chooses to sue the board, the HOA, for failure to comply with current law, query whether that issue will be covered by insurance. The second issue is similar in that if a homeowner wants to sue the board or any of its members, is that board now responsible and considered negligent for failing to abide by current law? And I think that's the most significant aspect of having this new affirmative requirement that CC&Rs be amended, because up until now, up until recently, at least the last year, HOAs were not required to update their CC&Rs to comply with current law. The idea had always been that current law would simply supersede any outdated CC&Rs. Not the case any longer, at least with respect to Assembly Bill 3182 and its leasing requirements. Let's see, I see a couple more questions on that. Oh, another good question. If I purchased my unit without the rental restriction and then years later they amend the CC&Rs, which one am I required to abide by? So there is a somewhat grandfathering aspect to this, in that if there was an older leasing restriction, that can apply to all the owners who are on title. But any new change in order to comply with current law would then apply to new owners who now take title post January 1st, 2021. That's a good question. Let's see. Our development requires that the property owner live in the property for a year before renting out. Will this still apply? This is where we get into the slippery slope of whether a particular leasing regulation is in violation of this new law. So as I mentioned at the outset, when I presented this, that HOAs are no longer allowed to restrict leasing or prohibit leasing unreasonably. And so the operative term is what's reasonable versus not, right? And unfortunately, that will have to be taken on a case-by-case basis. This is in addition to the very clear requirement that leasing cannot be prohibited under, or rather more than 25%. In other words, HOAs must allow at least 25% or more for leasing purposes. And that is a right that all homeowners have in these HOAs. In addition to that, however, HOAs also cannot unreasonably restrict leasing. So in that instance, hard to say whether the HOA can establish a compelling reason to require the property owner to live in the unit for a minimum of 1 year before they can rent it out. I can see a lot of arguments where that would in effect be a violation of the 25% minimum leasing rule. So it is a slippery slope and really will have to depend on the facts. Okay, so I think that's it on Assembly Bill 3182. One last comment. There, as I mentioned, there are a whole host of ADU related laws under this new bill, which I summarized in these last 3 slides, but I won't go into due to time constraints. But keep in mind that those ADU related laws sunset on January 1st of 2025. It's not clear to me, and the way I read it is that the Davis-Stirling Act change regarding leasing regulations does not sunset. Let's see, so we have a whole bunch of questions about CC&Rs getting updated, which is actually a good segue to my next bill, Senate Bill 323, which did go into effect January 1st of last year and pertains to election changes and the process around which elections are conducted. First of all, it applies to elections regarding assessments that require a vote. In other words, if the CC&Rs require some kind of election in order to approve a new assessment, and it requires a vote of some kind, then this new bill applies. The new bill also applies to election processes of all directors, board members, if there are such board members, and I'll get into that small versus large HOA dichotomy when we go into that. The new bill also applies to amendments to governing documents, and that's all amendments to governing documents. So as we were talking about, we now have this new affirmative requirement of HOAs to update their CC&Rs to reflect AB 3182 on leasing rights. Well, keep in mind, since last year, there's now this new election process for how HOAs are to lawfully amend their governing documents in order to comport with the new law that went into effect this year. And we'll get into at least a bird's eye view of that election process. And then finally, if the HOA grants any exclusive use to a particular homeowner, that also is subject to this bill. Existing exclusive use common areas do not count. It's only if the HOA newly grants exclusive use to a homeowner that this new bill would apply. There's also a big change under this new law that emails must now be added to membership lists, which is a huge relief, I think. In my practice, HOAs are required to maintain membership lists, which include their contact information, and homeowners have an absolute right to that information. There are some conditions around it, cannot be abused, but ultimately it must be accessible to every homeowner. Well, there wasn't any clarity until now whether that contact info needed to include an email address. And now Senate Bill 323 makes that clear, and that has been in effect since January 1st of last year. So some of the big things about this new bill with respect to election processes is that there must be an election inspector who is an independent third party. And independent truly means independent. It cannot be even the property management company that the HOA hires to handle day-to-day operations. However, it can be a homeowner, so long as that homeowner is not running for a board seat or is not related or live with somebody who is running for a board seat. As you can imagine, as a practical matter, there are a lot of questions around whether a homeowner, even if they're not running for a board seat, can be construed as having a conflict of interest by being the so-called independent third party conducting the election. But that is what the new law says. Another big change to this under this new law is that no voting rights can ever be suspended, even in the case of delinquent homeowners. I see a lot of CC&Rs that render delinquent homeowners suspended and not allowed to vote for a period of time until they come current. Those CC&R provisions are no longer valid under this Senate Bill 323, and that has been in effect since January 1st of last year. However, delinquent homeowners can be disqualified from being elected to the board. So a lot of CC&Rs that I've seen at least expressly state that delinquent homeowners are disqualified, but unless the CC&Rs or the bylaws expressly stated that, then there was no default rule under the Davis-Stirling Act that rendered them disqualified. So now, at least under Senate Bill 323, that is clear. As I mentioned, election timelines have changed. So there, as I mentioned earlier, there's this 90-day window where the HOA cannot change their election processes before a vote is conducted. And that means, for example, with the AB 3182 change, if an HOA needs to update their CC&Rs to reflect these new leasing rights, they have to update their CC&Rs first and have a 90-day window, and then update their CC&Rs as to the election processes, and then have a 90-day window before they vote on the leasing rights. Let's see if I caught everything here. If the HOA has a maximum rental, let's say 44%, the cap has been reached. Yes, so 44% is fine. And then what was the notification process by the state to HOAs about the change to the law? There is no notification process. As I mentioned, there isn't any central HOA agency that governs HOAs in California, but it's just as a practical matter that homeowners may have rights against the board if the board or its governing documents are not up to date and comporting with current law. Let's see, lots of questions around rentals that I missed. So let me cover those. If one unit of a 2-unit condo is rented out, frequently the condo cannot qualify for financing if the owner wants to sell it. This could be an unintended consequence of this new law. That is true. Query, however, whether the financing aspect is valid enough to overcome the unreasonable restriction limitation under the new law. If HOAs are not allowed to restrict leasing, for the most part, under the new law, is financing a good enough excuse to say, no, we got to limit it a little less than 50% or what have you? Remember, 25% is still the floor no matter what, and that's black and white. But if an HOA were to decide to go from 50 to 25%, would that even be valid under the new law? And that's not clear. And it's not clear whether financing is a good enough reason. So going back to these election processes, other aspects to this, let's see, I may have skipped some things. I think those were the major changes. There's quite a lot to the Senate Bill 323. In general, I recommend that if CC&Rs are I would say 5 years even or older, that it is worth looking into updating them, not only because of this new law, AB 3182, that went into effect this year, but also this one, Senate Bill 323, that went into effect last year, because the election processes really do cover such a broad category of governing matters that HOAs will encounter, such as assessments, amendments to the governing documents, and elections to boards, even if, or at least if there are board members to elect. That covers a really wide range of issues, and it is worth ensuring that your election processes are up to date. And the same issues that I mentioned before, if a board or an HOA is not comporting to current law, there is this liability, potential liability, where homeowners can say, the board is not comporting to current law and it may affect insurance coverage. It may present a negligence or worse type of civil claim. Speaking of claims, though, keep in mind that there is only 1 year to challenge the invalidity of an election process if the HOA, for one reason or another, failed to follow the exact process required under this new law. Homeowners really only have 1 year to challenge that. So for a lot of claims under the CC&Rs, the Davis-Stirling Act in general, enforcement actions entitle homeowners up to 5 years to challenge certain things. But in this particular case, election processes and the results, they can only be challenged for 1 year. So skipping to Senate Bill 652, this also went into effect January 1st of last year, and it's an express requirement now that HOAs not prohibit or ban putting religious items on an entry door or door frame. Apparently in the past, this had been an issue, and now there is some clarity around what can be considered a religious item, and then exceptions to that. And the exceptions are for public health and safety reasons. For example, if the item hinders the opening or closing of a door, an HOA is entitled to reasonably regulate that. The item cannot be obscene or threaten public health or safety. So there are some exceptions, but generally it is pretty easy for a homeowner to establish that something is a religious item and be entitled to post it on their door. There's also a new law, Senate Bill 326, that went into effect last year, and it applies to deck and balcony inspections. And the first inspection is not technically required until January 1st, 2025. But keep in mind that the inspection must be conducted by a licensed structural engineer. And often the shortage of available professionals becomes a problem. So it's wise for HOAs to think about this, because 4 years, just under 4 years now, can go by quick. And just quick summary of the requirements: this does apply to buildings with 3 or more separate dwellings. And as I mentioned, the report and the inspection needs to be conducted by a licensed structural engineer. And it has to be thereafter conducted once every 9 years. So some of you may have heard about a reserve study that HOAs are required to conduct once every 3 years. In this case, the deck and balcony inspections need to be conducted only once every 9 years. But a written report must be provided to the HOA. And as a practical matter, if there are any life safety issues, most likely the city or local governmental agency is going to get involved and mandate that the issues be corrected on a particular timeline. But keep in mind that this new law also reiterates this affirmative requirement of HOAs to report to local enforcement agencies if they learn of a life safety issue from the written report. This also only applies to elevated elements, in other words, decks and balconies that are 6 feet above ground level and are made substantially of wood or wood material. Unlike a reserve study, however, which is typically just kind of a walkthrough of all of the common areas and the development in general, this deck balcony inspection that is required really does involve somewhat invasive inspection, in that the waterproofing systems need to be checked. Sometimes, depending on what's discovered at a first inspection, further inspections are warranted. So it's a little bit more involved than your typical reserve study that occurs or should occur once every 3 years. But at least in this case, this deck balcony inspection only needs to be done once every 9 years. Another bill that I thought was relevant to HOAs, though it does apply to all real properties in California, and that is Senate Bill 234, which went into effect January 1st of last year. It now defines home daycares of up to 14 children. Up until then, it was only up to 8. And that does mean if you have CC&Rs that limit use of the condominium or of the unit to residential uses, which is fairly common for CC&Rs to say, keep in mind that a daycare of up to 14 children is now expressly allowed and still complies with the residential use requirement. So I'd like to also address a few important cases that came down the pike in the last couple of years. In HOA law, we don't often get lucky enough to have appellate cases that we can rely on. And so often we end up having to cite cases that were, at least 20 years or older. So it's somewhat exciting in our practice area when we have current cases where courts actually go to the trouble of publishing some important standards for how we apply things like the Davis-Stirling Act. The first one is Orchard Estate Homes, which was published in 2019. And it's not really an earth-shattering concept, but it does underscore a little known rule in HOA law, and that is addressing voter apathy, which often happens where you don't have a quorum, you don't have enough homeowners that are actually voting on a particular issue or electing the board of directors. And in this case, the HOA established that they did not have proper quorum. And so they had to petition to the local court, the Superior Court, in which they were located, to reduce the percentage of votes required, in this case, to amend the CC&Rs. Now, I caution you, if you ever look up this case, keep in mind it was passed in 2019, which is before the election rules went into effect in 2020. So don't really follow the processes that they applied, because arguably they would no longer be valid. But the concept to take away from this case is that HOAs are actually allowed to go to civil court and request approval of a particular issue if they do not have the requisite votes based on the CC&Rs. It's, as you can imagine, an onerous, potentially expensive process, but sometimes HOAs have no other choice, and it is an option available to them. Let's see. This case I thought was also really helpful, addressing maintenance and repair obligations of the HOA. The very first sentence says, this case is about whether condominium owners can make their homeowners association pay for a water leak. So in this case, it was established that the water leak was in common area, and HOAs are required to maintain and repair common areas and elements in common areas. And so the court did confirm that the HOA was required to address the common area water leak. But what they did go into, and what wasn't quite settled, was to what extent the HOA is liable for damages to a homeowner that is complaining about the water leak, especially when those damages start percolating literally into homeowners' units. If that water leak goes into the homeowner's unit, is the HOA liable? And the case left that question open, but it did establish at least that the HOA's failure to maintain a common area item, such as a water leak, does render it liable, at least under a breach of contract theory. So some interesting discussion there. Another point about this case I will mention also is that the court did consider relevant whether or not the HOA had a preventative maintenance plan. So something to think about, especially as a best practice for HOAs. I mentioned reserve studies every 3 years. A lot of HOAs, especially small ones, do not abide by that requirement, and that can present problems down the road if there is a common area issue such as a water leak. Because if there was no preventative maintenance plan in place and not even a reserve study to identify the cycles of each of these common area elements and how often and when HOAs are supposed to repair certain common areas, that's going to be relevant when it comes to potential HOA liability. Okay, before I move on, let me go into some questions I may not have addressed. I think I addressed this. Deck inspections must be conducted by licensed structural engineers. Not clear whether that also means pest control. Often they are the one and the same, but the law does say licensed structural engineer. And let's see what's in the chat here. Are HOAs now required to report the percentage of rentals? I think I mentioned that there's no reporting agency, but it is a requirement that HOAs keep their CC&Rs up to date, at least as to these new leasing laws, and arguably as to these new election processes, because failure to do so could present liability for the HOA. Okay, so final case that I wanted to mention pertains to assessments and delinquent assessments particularly. In this case, the homeowner became delinquent for failure to pay HOA dues, and there was a lien placed by the HOA, which is the next step. Typically, a lien is recorded against that delinquent homeowner's unit, and then they got a default judgment that entitled them to foreclosure and money damages. The problem in this case, the HOA didn't do anything about it. They did not foreclose. They didn't enforce their right to collect. Well, sure enough, 7 years later, the homeowner filed for bankruptcy, and the HOA attempted to collect the assessments that accrued after they had obtained their judgment. The problem with that is that's considered post or unsecured debt, post-judgment debt. And so the court held that HOAs cannot apply future assessments to an existing lien. So the lesson there is, if an HOA has a recorded lien against a particular homeowner, don't dilly-dally on it. Of course, there are meet and confer and alternative dispute resolution procedures that hopefully will resolve the issue between the delinquent homeowner and the HOA, but barring that, the HOA ought to outsource, ideally, to these third-party foreclosure services to really enforce their right to collect on the lien as soon as possible. It may not prevent bankruptcy, and that is often a reality that HOAs have to face, is a homeowner filing for bankruptcy, but it should not stop an HOA from promptly enforcing its rights when there is a lien and a delinquency. Okay, let's see, any other questions on that? Oh, okay, going back to the Sands case, the question about the source of the water leak. If it's not from common area, but from another unit, what course of action can be taken? I will say, to start, in response to that, often what happens as a practical matter is you've got the HOA and then the homeowner who was affected reporting to their respective insurance carriers. And so the insurance carriers often work things out and figure out who's liable, and if so, by how much percentage, right? But assuming the carriers have not figured it out, the source of the water leak is going to be a relevant factor to determining who's responsible. If it's the homeowner, especially if it's due to homeowner negligence, assuming that can be established, the homeowner is likely liable for all of the damages, including the damages affecting the common area. Do I have a favorite? Hi, Dan. Do I have a favorite risk management professional? I don't have a favorite. I'm happy to talk to folks one-on-one on people that I may recommend, property management companies and the like. And it depends on the need and the type of HOA and the number of units. I'm certainly, I certainly have some ideas for small HOAs versus large ones. And also, depending on the need, if one is looking for, say, the independent election inspector, that's one thing. If you're looking for someone who has day-to-day operations, that's another. So you can talk to me offline and I can give you some ideas. Let's see what else. How does the HOA collect on unpaid dues? Very good question. Will the state give them priority ahead of the loans? Also very good question. The answer is the HOA is required to provide certain notices. First, it's a notice of default to the homeowner, and then eventually a lien. The HOA can record a lien against that delinquent homeowner's property. Thereafter, a lien is just like any other debt or recorded debt on the homeowner's property, in that the HOA, like any bank lender, presumably, can foreclose on its lien and foreclose the property. It does not, the HOA does not get priority, however, over other recorded liens that were recorded either before the HOA's lien, or of course the mortgage, if there is one, by the bank. So the HOA unfortunately has to fall into position, and that is a financial evaluation that HOAs must take. But they do have the absolute right to foreclose on a lien, assuming it's been recorded. Let's see what else. Going back to decks, there's a question about third floor patio over living space. Is that considered a deck and thus subject to evaluation? The way I read the law is that it has to be a deck that's 6 feet above ground. So even if there's something above, below it, I read that to mean it's still subject to this new law, and the inspection needs to be conducted no later than January 1st of 2025. I also get a question related to that about whose responsibility is it? Is it the HOA versus the homeowner, especially if these balconies and decks are considered exclusive use common area? I'll mention briefly, exclusive use common area, it's really critical to understand, is technically owned by the HOA. It may have been given by the HOA to the homeowner for the homeowner's exclusive rights, exclusive use, but it's still under the ownership of the HOA. And that's significant because it really, the maintenance and repair obligations, including these deck inspections, really depend on what the CC&Rs say. If the CC&Rs are silent on who is supposed to be responsible for maintenance or replacement or repair of that deck, then the default is actually a HOA, even if it's just the exclusive use of one particular owner. Most modern CC&Rs, I hope, will specify homeowner who gets exclusive use rights is just responsible for all of the above: maintenance, repair, and replacement. In that case, if the CC&Rs are clear, then the deck inspection actually falls, the responsibility of the deck inspection actually falls on the homeowner. But I would say that the HOA actually has to enforce that and be the so-called condo police to ensure that that particular homeowner is complying with the deck inspection rules. That's how I read the law. And I would argue that if the HOA fails to enforce it as to that homeowner, that the HOA could be potentially liable under this new law. Let's see, there's some questions around small HOAs. As I mentioned, small HOAs is really just my informal term. There is no such distinction under the Davis-Stirling Act, but it ends up being the most contentious area of HOA law just because the dealings between particular people, between particular owners, becomes highly personal. And then there's the practical difficulty of trying to fit into all of these owners' rules, such as election procedures. As you can imagine, it's not really practical to have a secret ballot process when you have a 2-unit HOA, but that's sort of what we're stuck with. So there aren't any easy answers. That's a really case-by-case basis type of analysis. I welcome you to contact me personally, and we can address your particular situation. And I do have my contact information coming up shortly for those of you guys who were asking about that. So quick comment on COVID. HOA meetings during shelter in place have been, of course, a little bit difficult. But keep in mind, fortunately, the Civil Code, the Davis-Stirling Act requirements actually allow for remote meetings to some extent, as long as there's one physical location provided for the meeting. And so what I was advising HOAs to do last year, when there were no gatherings of any kind allowed, I always recommended that they notice a meeting with one physical location, preferably one of the board members' units, and then just ask everybody to remote in however they want to. Phone, audio, video, any of those are allowed, expressly allowed. And that was even before COVID, that the Davis-Stirling Act did allow for members to appear by electronic means, as long as there was one physical location provided. So that's the answer that you can still apply going forward. Of course, if people don't want to gather, and they shouldn't, in people's homes with third parties outside of their household, this is the way to handle it. Have one person at their home, everybody can Zoom in or whatever to conduct the meeting. However, keep in mind that email is not a proper way to conduct a meeting. So you can't just have an email thread saying, everybody say aye, okay, we're voting on something. It really has to be a live meeting with one physical location. And then final comment on shelter in place practical issues. During an emergency, and we of course construe the pandemic as an emergency, if there is a need for the board to meet and call some type of HOA business in direct response to the shelter in place orders or COVID, that there are some mechanisms to do so, so long as the board can establish that there's an emergency. So we had a lot of large HOAs, for example, who needed to shut down access to a common area gym or pool or some similar facility, and that was appropriate, and there was a mechanism for doing that. So just keep that in mind. Okay, so I'll take the last 10 minutes to address some of your questions. And while I do, here are all of my contact info details, email and address. And let's see, I don't have my phone number in here, so let me put that in the chat for you guys. This is my direct line, which is the best way to reach me. I can't always promise that I'm going to answer the phone, but I do promise to respond to your message as promptly as possible. So let's see, the questions around the decks, I think I answered. To what extent do these rules apply to TIC associations? That's also a good question. TICs are not HOAs. So I want to make sure that's clear. TIC is, probably many of you know, stands for tenancy in common, and it's really just a form of holding ownership. One does not even need a so-called standard TIC agreement in order to hold as tenants in common to a piece of property. And the main distinction is that so-called TIC property is on one parcel, one piece of land that owners are allowed to privately decide among themselves, ideally in writing, to say, I'm going to get exclusive use of the upper unit and you're going to have exclusive use of the lower unit, and we're going to divide everything 50-50. And as you know, probably many of you know, there's TIC agreements out there that have a whole host of different rights and obligations that all the TIC owners have to abide by. But the key is they are essentially co-owning a shared piece of property. An HOA, by contrast, consists of multiple condominium units, or as in a planned unit development, multiple properties that are governed by a set of governing documents like CC&Rs, often bylaws, where they share common areas, and those common areas might be hallways, might be sidewalks, but they are all a part of this development. And those HOAs are governed by the Davis-Stirling Act, whereas the TIC ownership, co-ownership situation is not governed by the Davis-Stirling Act. So that's really important. All the bills that I've discussed today apply to HOAs and not TIC co-ownership situations. TICs are often governed in effect by common law real estate principles, things that courts may interpret from time to time, but there is no statutory regulation of TICs. Let's see, I had a question about ADUs. HOAs, can HOAs enforce old CC&Rs that used to regulate or limit perhaps ADUs? The answer is no, not just under AB 3182, the first bill I addressed, but also there were some changes to the law last year. And so in general, an HOA cannot limit the construction of an ADU, subject, of course, to the myriad of different local code requirements. But the HOA on its own cannot unreasonably regulate the ADU. Let's see, any other questions here? I think that's it. I did post my phone number on the chat box, so hopefully all of you guys saw that. And then here's my email, which also is a great way to contact me because I do check it often. Probably too often, but it is a good way to get a hold of me. More questions around ADU, which is probably the subject of a whole different discussion and presentation, but, and I'll just post my phone number again. But just keep in mind, as it pertains to HOAs, which is the focus of today's topic, rentals do not include the renting of an ADU. The concept being that the owner presumably lives in the unit and then is renting out the ADU akin to a roommate situation. But in any event, that's the change to the Davis-Stirling Act, which applies only to HOAs, not any other type of co-ownership situation. Let's see. Well, I will just read my phone number aloud. It's 415-926-7630. Hopefully you guys can see that posted on the chat box. And as I mentioned, phone, if not email, is really the best way to reach me. And what I always like to do is answer your questions first to see if you think your client, typically it's going to be your client who needs some legal advice. And that way we don't have to go through the rigmarole of a conflict check. If you just give me kind of a general sense of what the issue is without naming the property address or the names of the people involved. In that case, I can give you some very general advice in response. And based on that, ideally, you can determine whether your client needs an attorney for further advice. At that point, of course, we will have to conduct a conflict check because we do represent HOAs and homeowners alike. But hopefully by then we have teed up what the issues are and what your client's needs are. I will say my phone number again. It's 415-926-7630. Let's see, did I cover any other questions? Any questions that I did not cover, in other words? I saw some raised hands. I'm not sure if anybody wants to talk still of those people that raised their hands. Astrid, did you still have a question? Yes, no? I unmuted you. Okay, let's go to Melissa Elena. Did you have a question? Nope. Okay, well, I'm just gonna look at the question and answer and chat boxes one more time. Charges, that's actually very important. We do charge by the hour generally. Depending on the need, we may need to open a file and request a retainer in advance. Our attorneys' rates range anywhere from 300 to 500 an hour. And of course, that also depends on the needs of the client. Something somewhat simple, we may have a less experienced junior associate handle, but of course, if things get complicated or messy or even on the verge of litigation, your clients will prefer to have a more experienced attorney handling things. So we do address the hourly rates depending on the need and the issues at hand. One more comment also, I've been talking a lot about CC&R amendments, and so inevitably we're getting a lot of requests to help HOAs navigate that process and even prepare the CC&R amendments needed. We will handle those on a case-by-case basis. We also have several referrals of other attorneys and colleagues in the community that we recommend. So again, I welcome you to contact me. We'll figure out what the need is, and then we'll decide whether it's a better fit for us or one of our contacts, our colleagues in the industry. So I invite all of you to contact me, and hopefully this was helpful. I promise I will send a recording as soon as I can, as well as this slideshow. Thanks so much.